want to fend for myself, and I want to build people up for them to fend for themselves. Attorney Jeff Russo of Warren County, New Jersey. Welcome to the show.
Thank you, Clark. Honored to be here.
You have somehow become a specialist in sex abuse cases, litigating for people who have been abused and winning multi-seven-figure settlements and for multiple victims. So I thought you were a perfect fit for the show.
It's an honor to be here with you. I appreciate you referring to me as a specialist. Wasn't by choice. This wasn't my career path, but it's become a passion of mine. And kind of happened by happenstance. And here we are. And now I'm with you.
You just started telling me a story before we began airing, and I said, "Hold that story." And you're talking about your first one of your first cases.
Yeah. So when I started, my father's an attorney as well, and my brother is younger than me. He later joined our practice. But when I first started, a case came in. It kind of came in through my uncle, and I was very green, so to speak, and it involved child pornography. I'd never seen, of course, child pornography, and there was like 7,000 counts child pornography that this person was charged with. So one of the things that I learned is that there could be an issue, right? They have 7,000 images as to whether or not the individual depicted is a minor. So as an attorney, you have to look through the evidence. Now, child pornography, just like an assault rifle, just like illicit drugs, is contraband. So when you have a criminal case and you're representing the defendant, they have to turn everything over to you. But of course, they're not going to turn over contraband. So I had to go to the state police barracks. And I'll never forget this. I was very young. And they had a stack of images face down. And the trooper said, "Okay, have at it." And I looked at one image. I immediately put it back down. I was overcome by complete disgust. I felt sick. That was quickly replaced by anger. The anger was at the adults that put a kid in this position. I can't get that image out of my mind. I walked out, never had a child porn case again, would never take it, never took a case. I did a lot of major criminal work. I never took a case of any allegations against a child, any sexual allegations. The rule I had was, I may do it, but you have to pass a polygraph. And I would use who I believe is the best polygrapher in the country, Jerry Lewis. He retired from the state police. And if Jerry said, "Yeah, I believe this guy," then I would take the case. We became known as the firm that kind of were a little wacky, a little crazy, litigators. My father kind of developed a reputation, and he earned it as a true fighter. And we would take the cases that other attorneys wouldn't. So I was doing a lot of criminal work, some civil work, for plaintiffs. And one day, and this kind of ties into your story as well, it seems the Sandusky scandal and the horrors that he was involved with and he committed was almost a positive for many survivors and many victims, and started to empower many people to have the courage to come forward. I believe it also started kind of a cultural shift where we get away from the shame of victims and we start to slowly progress into embracing victims and survivors, which of course is the way it should have always been. So shortly after this Sandusky comes to life, an individual comes to our office. And he came to our office not as a first choice, but the so-called specialists in child sexual abuse cases representing victims at that time wouldn't take his case. And they wouldn't take his case for a number of reasons. It didn't involve one of the hot-button defendants, the Catholic Church, the Boy Scouts. Those cases were kind of already made. They were starting to develop funds. I don't want to say that they were easy cases, but from an attorney's perspective, oh, okay, we have a Boy Scout case, that's known. This would have been the first allegation, formal allegation. We'd learned, of course, there was many, many allegations against this individual. The other problem was, which was the big one, the statute of limitations had run. So all the other attorneys evaluating this said, statute of limitations ran, and that's a major hurdle, not insurmountable, and we're not taking your case. So where does it end up? On Russo's lap. At that time, I was focused on, and this was maybe 2012. At that time, I was focused on major criminal litigation, and I really enjoyed it. My father and brother were doing the major civil litigation. So they evaluated it. We said, this is going to be tough because of the statute of limitations. They came to me and they said, you technically are a part of our firm. Are you okay with us taking this? And we all collectively agreed, win, lose, or draw, this is the right thing to do.
This episode of the Free Like Me podcast is sponsored by Scarred, a memoir of a childhood stolen and a life reclaimed by Fredericks. Available now in all major retailers and for Audible listening.
So they take the case. And we've been involved in really arduous, aggressive litigation, but nothing on this scale. So my father and brother were litigating this, and they said, I said, guys, every day I see, when you're involved in civil litigation, we call it motion practice, right? A motion's asking a judge to do something. A car accident, even medical malpractice cases, sometimes there's at most maybe 10 motions. Every day I'm seeing motions. I'm like, what is going on? And they said, Jeff, you'll never believe this guy. I've never seen anything like it. When I say this guy, I'm referring to the attorney that was appointed by, this was a case against Warren County, appointed by their insurance carrier. I said, come on. I started to look at it. I said, this is obscene. This is the worst tactics I've seen in litigation in terms of trying to draw out litigation, harassing litigation. And I'm thinking, from a trial perspective, why would you do this to a victim of child sexual abuse? And it shocked me. Thereafter, that case actually led to this individual. When I say this individual, aside from the attorney appointed by the insurance company, these cases were against the head sheriff of Warren County, Edward Bullock, the head guy.
Very, in this area, very famous,
Notorious.
Notorious is more the word, yeah.
So what happened was, his case, our first client, was so compelling. The prosecutor's office, now this was, so Bullock, to kind of go back, was a sheriff in Warren County about 1982 to 1991 in his arrest. We can get into that. It's a very...
well, the audience needs a little backstory of
Sure.
like who this guy is. And
So Edward Bullock was elected sheriff 1982. He takes office, okay? And he's a hulking, massive man. 6'6", probably close to 300 pounds, wore a cowboy hat, pistol on his side. By the way, no formal law enforcement training. The sheriff. And as sheriff, and what I speak about are not my opinions, they're not conjecture, they're evidence. They're either documentary evidence that's public record put before a jury or testimony from witnesses. And what he would do is, as the sheriff, we had, in Warren County, there was a children's shelter. And that was an overnight facility reserved for kids in all types of awful situations. Parents abandoned them, parents on drugs, they were violently abused, whatever the awful situation is, they had nowhere to go. That was supposed to be their safe place. The other place in the county, actually close in proximity, was the juvenile detention facility. It was called Warren Acres. And there you would have kids. Most of them had, significant issues. But, as one of my clients who was on your podcast, he was in there for stealing a pumpkin. So the sheriff's department in Warren County was charged with the transportation of these kids from the shelter to maybe a doctor's appointment, from the shelter to court, from Warren Acres, the juvenile facility, to court, back and forth. It was the sheriff's officers that were charged.
Sheriff's officers, not per se sheriff.
Of course.
Right.
So the black and white protocol was, when you're transporting a kid, you have to have two sheriff's officers. If they're coming from the detention facility, either from the detention facility to court or from court back to the detention facility, the protocol was two sheriff's officers. The child had to be in the back seat, handcuffed and shackled. Now, when I first started practicing, it was very commonplace to see juveniles, and I'm not just talking handcuffed, foot shackled too. Thankfully, that has been reformed, and I hardly ever see. In fact, I don't think I've seen a juvenile in handcuffed and shackles in 15 years. Complete reform of our juvenile system. But at that time, that's the protocol. So what Bullock would do, he's the guy in charge. What Bullock would do is he would study, he would figure out, he would hand select certain juveniles, either in the from the shelter, from Warren Acres, or in the courthouse. And if he liked you, he would first, and it's like habit and routine. He did the same thing. He would target kids, always boys. Most of the time, blonde hair, blue eyes. Almost all of the time without a father figure. And he would either take the juvenile, he did many different things, but he would take the juvenile, they had a holding cell for juveniles. He would come in, he's the boss, he would come in, unlock the bars, go over to the juvenile, say, hey, I want to have a little talk with you. I really think I can help you. I talked to your mom outside and I told her I could kind of give you some guidance. It looks like we're going to get you back on the right path. Now, this could be anywhere from a 10-year-old to a 16-year-old kid. And he would take them into his office. No handcuffs, no shackles. Go into his office and close the door. Over the years, this happened over the years. These would be considered his counseling sessions. This is what the witnesses would do, and I'm talking other sheriff's officers. Oh, little Joey's in there for some hands-on counseling. And he would take him in there, sometimes give him candy, cigarettes, make them feel important, make them feel good, start to gain their trust, typically known as grooming.
Yep.
He was so open and notorious and arrogant about it. He would go into the courtroom with the kids, rubbing their shoulders in front of everybody, in front of the judge, in front of all the sheriff's officers, in front of the attorney, everyone. Many people have testified to this. He would do this countless occasions. Countless occasions. Now think about it. He had almost a 10-year run here. Free reign children. Before I get too ahead of myself, he confessed. So this isn't, rumor, innuendo.
Allegation.
This isn't an allegation.
Right.
This is what he did. The horrors really happened when his favorites, and there was a lot, would need a transport. Everybody else is transported. 2 sheriff's officers, handcuffed, shackled, or the kids from the shelter were not shackled, but they always had to be in the back seat of a sheriff's car. Not with Bullock. He would pull up Warren Acres or the shelter, say, I'm going to take little so-and-so. Never handcuffed, never shackled. Right in the front seat. Right next to him. He had this big bench seat in his car.
Against all protocol.
Against all protocol. And the workers at the shelter and Warren Acres would see this constantly. And I won't get into what would happen on these rides, but I can tell you the worst child sexual abuse, rape, molestation that anyone could imagine.
By a 6'6", towering 300-pound hulking monster.
With a gun. And your life as a child, imagine this. Obviously you're in the shelter or Warren Acres for a reason. Now you have the head law enforcement officer in the county doing horrific things to you and scaring the hell out of you. And he will make sure you don't say a word. Now, we've had some clients that have talked. Testimony from one of our clients at trial. I came back, was bleeding from his rectum. And I told him, because they would be strip searched upon re-entry. He was punched in the stomach and told to shut the blank up.
Punched in the stomach by who? A guard?
A guard. This was known from the early 80s. Known. It was a joke in the courthouse. A joke. Testimony, evidence. Where's so-and-so? He's coming with the sheriff. He's getting a special ride. Imagine this. The devastation, and I don't have to tell you because, unfortunately, these same horrors happened to you. Mm-hmm. But the devastated lives that could have been prevented. Nobody intervened. People reported it. People reported it from the very beginning. To their supervisors, to their bosses, to the individuals that ran the institutions. Never stopped. Never blind eye. It was a wink and a nod. I could go on and on and on about the evidence that was presented. But what bothers me and what haunts me about your situation, it could have been prevented. For this to be so open and notorious that it's the butt of courtroom jokes at the expense of the lives of children. I'm a man of many words. Leaves me speechless.
I don't know how people live with themselves. Like, I don't understand that.
I've had county employee after county employee. Yes, we saw this. We knew what he was doing. We have testimony. We believed he was committing a crime. This isn't rumor, innuendo. All the witnesses we had, they said everyone knew. It was common knowledge. Despite all this, no intervention. How many kids' lives were ruined because of this? That's what bothers me. That's what bothers me about your situation. Oh, it's Denny Pegg? We know.
Yeah.
We know.
Yep.
How different would your life have been had that not happened to you? But how I got into this work was my father and brother could no longer be in the room with this attorney. So they thought me, everybody gets along with Jeff. He's a jokester. He's a people person. We can't be in the room with this guy. Let's let Jeff do it. After about 13 seconds, I couldn't do it, but I had to. And I went through years.
Can I just stop you 1 second?
Sure.
Like when a guy's making motions almost daily, a judge doesn't have the authority to be like, this is just obscene and ridiculous. Stop it.
Great question, Clark. Yes. Here's how crazy this got. The courts, now remember, throughout most of this, then it kind of went into COVID. Our vicinage, right, which, encompasses 3 counties, had a judge shortage. We would always have, it's called the assignment judge, which is the head judge. We always had the assignment judge on these cases. It got so crazy, the assignment judge did what other judges would do, and I would have done the same thing in, class action, mass tort litigation. They appointed what's called a special master. And they set up a procedure. They said, this case is so out of control. The court doesn't have time. Of course not. The court's not a babysitter. So they appointed a special master. And the first gentleman, great guy, he got involved with this. He had enough. In very short order, he quit. I think he quit without even being paid. And I felt terrible. He's a great guy. I believe he's a judge now, actually. He was a gentleman, but he couldn't handle these antics. After that, the court said, okay, we're going to appoint a retired assignment judge, a gentleman by the name of Judge Gallipoli. He was the assignment judge in Hudson County, and he was tough. And he started to get the case back on the rails. It got so bad. In the course of civil litigation, we have something called a deposition. Each side's allowed to, it's kind of in an informal setting, but it's under oath. You can ask some questions. Normally it's a half a day at the most. The county's attorney started taking, of the victims, 4 and 5 days. These guys were tortured. It got so bad, I had to hire a videographer, not to videotape the deposition, to videotape the attorney. Then Judge Gallipoli said, that's it. This is ridiculous. The depositions will be in front of me. And as soon as that happened, unfortunately, 2 of our clients had already been subject to this, really torture. As soon as that happened, depositions lasted very quick. And Judge Gallipoli, thank God, was there to protect the victims. So we actually got to the point where, now we're paying the special master, right? And rightfully so. I mean, he did a lot of work. But I'm thinking to myself, we're up against insurance companies with billions of dollars. We're trying to get justice for victims of horrific child sexual abuse. How is this fair? I said, I had enough of this. So we filed our own motion with the court. We said, look, here's all these motions they filed. Here's what they did. We shouldn't have to pay for this special master anymore. And the assignment judge wrote a very, very long opinion, and he said, you're right. He actually said, which I thought was poignant, now remember, this is child sexual abuse litigation. Here's how this was handled by the defendants after I filed this motion. Here's what the court said. A fair review of the litigation tactics here indicate that the county, Warren County, has engaged in a war of attrition, which is likely designed to wear out the plaintiffs. Judge further described it as vicious and zealous litigation tactics, which perhaps even cross over to overzealousness. Court went on. In this court's 40 years of experience as an attorney and as a judge, it has seen few cases where such a scorched earth litigation strategy has been implemented in such an obnoxious degree and to the detriment of other litigants. That's the court's words, not mine. That's what we went through. And when I say we, my clients too. So yes, to answer your question, courts can, get involved and put a stop to this, but there's a lot of leeway in civil litigation. And what happened after all this? After over 10 years, I believe, finally got a trial date.
Wow, it took that long.
Yeah, and it wasn't the court's fault. Then we had COVID, right? Then we have a judge shortage. And the trial, I was so relieved because now it's the great equalizer. And what happened, by the way, this litigation lasted so long because of these tactics. The law changed.
Bingo.
In no large part because of you. You and other advocates tirelessly advocated for the rights of child sexual abuse victims. And you, better than anyone, knows that when something this horrific happens to you, especially as a kid, your life goes off the rails. Mm-hmm. My guys, I could tell stories, and I live with it every day. And I've always felt a sense of guilt. I talk to some of these guys almost every night. And I've always also, other clients, they're depressed, I can relate. I always felt guilt because I couldn't relate to these guys because it didn't happen to me, and it made me feel guilty. And to see what these guys had gone through and went through, I couldn't explain that to another person. You understand it, but I couldn't verbalize it. And I tried, my God, a part of this litigation, you fight in court. But it's not like a regular client where, they were in a car accident. Okay, follow up in a couple months, see how your treatment is. A lot of these guys, I'm the only person they ever told. And, I probably should have some better boundaries, but I want to help them so much. So I take their calls. Sometimes, they're in a really dark spot. Sometimes they're under the influence of something. Sometimes they're in, God only knows what situation. And it wears on you. It really wears on you. But, for example, CC, you gave him a gift that I could never give him. And I don't know what you did, but that's a perfect example of how you could relate to a victim, I couldn't.
Right.
And now, CC, I can't even express the degree of how changed he is for the positive. The relief I feel when I see him, when I hear him talk now, when I hear him talk in front of other people, I'm like, it's shocking to me. I came to one of your events. You were nice enough to host a suicide prevention event, and he spoke.
Yep.
And I'm teared up because he's making jokes. He's happy. He feels, that's why I like the name of your podcast, Free Like Me. But I labored with these guys, and I'm going through it again, because after, this, it empowered more people to come forward. But going back, trial's the great equalizer. And now all those years of what they did to us as attorneys, what they did to the victims, now it's up to a jury. No more filing motions, no more harassment. Now it's game time.
Can you recall how many motions? What are we talking? Dozens?
No.
Over 100?
Oh, yeah.
Oh, really?
Yes.
I had a murder trial, murder case, and there was just a couple of motions.
Now, don't forget, the way this was set up with the discovery master, this is why it became so expensive, and the court allocated the fees differently. It made them pay for the lion's share. The discovery master, they would file a motion with the discovery master. We would have to oppose that. The discovery master would make a decision. Then the process was, this is different than regular litigation, then you appeal, they would appeal that decision to the court. Now you're essentially, so every motion is almost like two motions.
Ugh.
So when you talk about a full-time job, I did, my brother is really the smart one, the brains of the operation. And when I go back and look at it, he was on the forefront of this litigation statewide. When we would talk to the so-called experts on this, they would abandon claims under the Child Sexual Abuse Act. I'm like, guys, what are you doing? Nah, just proceed on what we call common law claims. And I refuse to do that because the Child Sexual Abuse Act is what we call remedial. And it's set up to stop child sexual abuse. And the remedies in there, including punitive damages, attorney's fees, because they want to entice attorneys to take these cases, even if they're difficult or maybe they don't feel like they can maximize the damages and get paid. But it's a statute. It's like a civil rights statute. We want, the lawmakers want change to occur. What is that change? We don't want kids, children, or anybody being sexually abused. So, as I was saying, in the middle of our litigation, because of your work and many other advocates, the law changed and the statute of limitations changed. So that relieved us then from having to show why the statute was missed and kind of, there's this test, it's called a Lopez test if you miss the statute of limitations. But we were prepared to do that. All of those tactics backfired. And it backfired in a major way. Because now, under the Child Sexual Abuse Act, they would be liable, if we won, for attorney's fees, expenses. We had the best experts in the country. Punitive damages.
Just 1 second. People are always under the assumption, an attorney gets a third of what's awarded. Are attorney's fees taken out of, say a victim gets awarded $1 million? Do you get a third of that, or your third is on top of that $1 million, so they get the clear $1 million?
That's the beauty of the Child Sexual Abuse Act. Okay, if you succeed, right? The Child Sexual Abuse Act is a statute, and it basically gives a civil cause of action, a civil right to bring against one of two people or entities: an active abuser, which would, in our scenario, would be Bullock, and a passive abuser. A passive abuser is an individual or an entity that knew or should have known what was happening and acquiesce to it. If you prevail under that statute, you get attorney's fees. So a jury verdict, so let's say the jury says, yes, there's a violation of the Child Sexual Abuse Act. We award $10 million. The plaintiff gets a $10 million. We would then get attorney's fees for, however long the case went. The problem with what I was advised to do by the experts, don't include the Child Sexual Abuse Act. And the reason they weren't including it is because they're fighting over it, right? The interpretation of it. Okay, great. I'll fight over it too. This is meant to protect victims, and I'm going to make sure it does. The problem, you take out that act, now you're in a contingency like you talked about. So if they award $10 million, now a third goes to your attorney. And there's hybrid things and what have you. But that Child Sexual Abuse Act is the most powerful act civilly in the state. More powerful, in my view, the law against discrimination, which is remedial, very admirable reasons we have that. But the Child Sexual Abuse Act even goes further in terms of damages and what you can get. Civil Rights Act, stuff like that. So I took the position, I don't care if there's a fight over interpreting it. I'll take it to the Supreme Court. And I got what I asked for in a different case, but I'm now before the Supreme Court with the interpretation of how that act applies.
I told you I'd like to join you when you go to the Supreme Court to sit in. We'll see if we make that happen.
I would love to have that because I think what's happening is, and again, it's very clear. You have victims of child sexual abuse, okay? There's a lack of resource, right? These guys aren't multimillionaires coming in, going to hire the best experts and what have you. It's the polar opposite. And normally it's the polar opposite because of what had happened to them and how that changed the trajectory of their lives. They're up against multi-billion-dollar insurance companies. Now, these insurance companies, what do they want to do? They're in business. They want to save money. How do they do that? Well, in one respect is they challenge the laws so that the law is interpreted in such a way that really minimizes their exposure. And that's what's actually happening right now with the Child Sexual Abuse Act.
What are they saying, what the loophole is in the Child Sex Abuse Act?
Through your efforts, through other victims' efforts, there was sweeping reforms to not only the Child Sexual Abuse Act, the statute of limitations, immunities for public entities, and what have you. And there's been some iterations, some modifications, some changes because the law's so sweeping. There were some, fixes that were made. Right now, not related to these Bullock cases, I happen to have another case where, as luck would have it, was the same attorney. And this attorney's position was that the Child Sexual Abuse Act was enacted, formally put into effect in December of 2019. And to me, to the plain language, to really, I think, a layperson's and a legal person's understanding is that this was to elongate the statute of limitations. So now it's till your 55th birthday. And then you can get justice, right? Where's your justice? It's under the Child Sexual Abuse Act. And yeah, there's common law claims, negligent hiring and all this kind of stuff. But that's the heart of it. And what their interpretation is, or what position they took was, the abuse has to happen after December of 2019 for the Child Sexual Abuse Act to apply. And the reason they took that position is the Child Sexual Abuse Act used to read, again, for a passive abuser, right? Passive abuser could be the Catholic Church, the Boy Scouts, in my case, the County of Warren. It used to read, and it kind of came from an old criminal statute, but it used to read, to qualify as a passive abuser, the child had to be in loco parentis, which is Latin for in place of the parent, within the household. Everybody's like, well, within the household, what does this mean? And that came from an old kind of Title IX statute. So the way that had been interpreted before these reforms was to proceed under the Child Sexual Abuse Act against a passive abuser, you had to be within the household. And that was interpreted as overnight, a juvenile detention facility, an overnight shelter. Not an issue in my Bullock cases, but that excluded, oh my God, day camps, all public private schools, 95% of cases.
Catholic Church abuse.
Correct. When those sweeping reforms were made, they took out within the household. So now the requirement, which makes more sense, is you just have to be in loco parentis. School, could be Catholic Church, in place of the parents. No more overnight stuff. So now that would give victims, rightfully so, the right to recover under the Child Sexual Abuse Act. They took the position, oh, no. The abuse has to happen after the law went into effect. And I'm like, come on. So our trial judge in that case said, no. Here's the law. Here's what it says. As long as you file it on time, you don't miss a statute of limitations, this is the law that applies. Within the household's out. It's only that makes sense. The appeals court actually took the case on an emergent basis, right? You can't appeal a case until the end. There's very, very few exceptions. It's called an interlocutory appeal. You have to get permission because we don't want every little decision a judge makes appealed. Cases will last for a million years.
Right.
So I win that interpretation, and my adversary.
Now, yeah, I was just going to say, who's bringing all this?
Well, it's funded by insurance, right? This happened to be the same adversary as the Bullock cases, right?
So he sort of got his behind spanked in court, spanked by that judge about all the motions and everything, and then he comes up with this avenue to sort of give you a jab back. And
he tried the same tactic in those cases as well, but it didn't matter in the Bullock cases because they're within the household. That was irrelevant. So I don't know if he's giving jabs or what he's doing, but he's, it's unlimited money, right? So he can just file. So what happens is the appellate division, very rare, the appeals court, grants that request to stop the case and appeal it. They grant it. I'm like, ugh. And through my work, I was able, the defense has a tremendous insurance, powerful lobby. They know what's going on in every county, and they're coordinated efforts. The plaintiffs don't, right? We're representing victims, trying to get them justice. But I was able to develop a pretty cool network of people. There's actually a super awesome father-daughter team, the McCanns down in South Jersey, representing victims. I got hooked up with the bar. I wasn't even a bar association member, right? This is how off the grid I am. And I ended up starting to do public speaking engagements with former Senate President Sweeney about the laws and what have you. So I kind of developed some contacts. And in the appellate division, the state bar, which is Switzerland, they don't take a side one way or the other because they have defense attorneys, plaintiffs' attorneys. But this is so compelling. The state bar decided to request permission to participate on behalf of the victims. That was granted. Child USA, awesome advocacy group. They were granted permission to participate on behalf of the victims. And the New Jersey Association of Justice. And they've been awesome. They've helped me. We've supported each other. So we did all the briefings, went to the appellate division. The appellate division unanimously agrees with the victims. It was a published decision, which means that's the law. Great. Great day for victims. Nobody participated on the defense side. We won. Opened the gates for no more nonsense. Now victims cleared the path. Supreme Court decided to take the case. Now, the Supreme Court, that's also discretionary, and so that's where we are right now. So now that interpretation will be heard by the highest court we have, the Supreme Court. But this time, there's lots of organizations jumping on the bandwagon against the victims, including the state of New Jersey.
When you say the state of New Jersey, you told me the Attorney General's office?
The Attorney General's office filed a motion to...
which is very disappointing to me to hear that.
Well, to be honest, Clark, when I saw it, right, a motion to participate amicus, in other words, a friend of the court, right? So you have a lot of this, like, in like an abortion case, right? U.S. Supreme Court groups want to participate, even though they're not a direct party. When I saw that motion to participate from the Attorney General, I assumed it was on our behalf.
On your behalf, right? Victim's behalf.
It was not. That was quite unsettling. So now, right, we have the school districts now are participating. All these national defense insurance firms and all this kind of stuff. I still have my core group. Just great salt of the earth people still fighting, advocating, for the victims. So we'll see. So that oral argument hasn't been scheduled yet. Briefing's just about done. But I could see how you would be disappointed, especially all the work you put into.
Yeah.
It would be surprising to most victims to say, here, this is the heart of the Child Sexual Abuse. This is the Child Sexual Abuse Act, but we extended the statute of limitation. You're 55, but you can't proceed under it.
Yeah, unless it was an overnight.
Unless it was overnight.
And like, how many abuse cases are actually overnight?
Correct.
Right. Wow. If a coach is doing something, with a student, if a doctor, in an office visit, it would negate all of that.
Under the to proceed under the Child Sexual Abuse Act, yeah.
And when was that when was that wording removed about the overnight? When was that taken out?
So that was all part of the initial reforms.
The reform we got passed.
Yes,
that was still in there.
No, the reform you got passed, it was out.
Oh, it was taken out then.
Yes.
Okay.
Yes, and then now, if you remember, they had that 2-year window.
Yeah.
That you could. It didn't matter how long you could file and what have you. So. I mean, there was even fights about if it's a public entity, right? A victim had to show that they paid $3,600 in medical bills, or they had no case against a public entity under the Child Sexual Abuse Act or even any common law causes of action. Court said, yeah, that's what it says. They changed the law to fix that. So there has been some, even when Governor Murphy signed the law, he said, listen, I'm going to sign that. I'm going to sign it under the promise and representation that certain things are going to be fixed, that public entities are treated equal as private entities, like a public school, private school. And he did. And he wrote this signing statement advocating for the victims and, kind of championing the day and really applauding these reforms, which were long overdue. So, yeah, I mean, quite surprised to be in this situation. Let's see, it's 6 years later.
Yep.
6 years later. But, yeah, I certainly share your shock.
Yeah, I could.
Especially all the work you've done.
Well, you've won at 2 appellate courts,
No, so we won at the trial level,
trial level.
and then we won unanimously in the appellate division, right? It's a panel of 3 judges, so we won unanimously, and it was reported. So a lot of the decisions, the court can decide if it's going to be reported or not reported. If it's not reported, it's not precedential, technically. If it's reported decision, that's the law.
And this was reported.
It was reported, yeah.
And that being reported, the Supreme Court will look at that.
Oh, yeah, of course.
Right.
Of course. Now, it could be, and I don't want to speculate, it could be that the Supreme Court wants the final say on it.
Okay.
You always prefer, we already won, and, we already kind of paved the way for victims. Let's leave well enough alone. But the Supreme Court has the absolute right to take the case. It's discretionary. It's their right to do that.
Now, you saw at the appellate level what their angle was, to try to win over you, and yet you still won. Do you have an idea what they're going to try to take what angle they're going to take at the Supreme Court?
It's the same argument.
That's it.
It's
right?
the identical argument, right? So their position is the appellate division is wrong. There's really nothing more to the argument. That's the position they've taken. Difference being this time there's more, not direct parties, but there's more individuals, and I shouldn't say individuals, entities participating.
Okay. Wow. Yeah, I'm looking forward to getting that resolved.
Yeah, well, I'd love to have you there because all your hard work. You should know things like this, and listen, this happens with new legislation and what have you. But what's right is right, and the appellate division hit it right on the head. Like it doesn't make sense. You're gonna expand the statute of limitations, make these sweeping reforms, but the change to the Child Sexual Abuse Act is not going to apply unless the abuse happened after 2019. I mean, it would create absurd results.
Right.
And that's what they've realized. I mean, I have a case I haven't filed yet, but I've had abuse happened before December of 2019 and after at a school. Where I tell my client, hey, listen, good news. You can recover for half of it. You imagine trying to parcel out child sexual abuse? Well, these 2 acts you can recover, but sorry, not this one.
All right.
It's silly.
If I'm a sex abuse survivor and I'm listening to this podcast and I'm in New Jersey and I haven't come forward yet, and I hear this and I hear your success with litigating for victims, and I'm thinking of calling you, what's the process from that first phone call? Who do they get on the phone when they first call? Do they talk to you on that very first call? Do they talk to an assistant, a secretary? Just take me through what's going to happen.
Well, first of all, everyone should know that anytime you talk to an attorney, it's strictly confidential, no matter what. Very few exceptions. If I think my client's going to go and imminently commit a violent crime, ethically, I probably have to do something there. But first of all, it's all confidential. Secondly, some individuals call. They don't want to leave their name. They don't want to give any details. They just want to talk directly to me, and that's fine. So what would happen is, if I'm available, I'll normally jump right on. If I'm not, I'll call the individual back. And there's nothing I haven't heard. There's nothing I haven't talked to a client about. I mean, each situation is uniquely different. I'm amazed at the differences in all the variables and the traumas and how people deal with it. But they should know that it's confidential, and they should know that we truly, truly are champions for child sexual abuse victims. And I think, as we've demonstrated, we'll stop at nothing until we get justice. And I'm also very honest. I'll tell someone, listen, here's, I think, the issues, here's the problems. And what I always do is I explain, best and worst case scenarios in terms of participation, trial, what have you. Because I never want someone to get involved with something and not see it through. So I try to explain everything. And then a lot of people, sometimes for whatever reasons, I don't take their cases, but I stay in touch with them because, we've developed a rapport. My clients have become like family. I find myself talking to victims at all hours of the night, weekends. I actually called a client on my way here because I was reflecting on the drive. And I kind of wanted to know from this individual. I said, hey, I'm going to go on this podcast. This isn't, and by the way, this isn't something I normally do. I truly am honored and admire what you have done. Not only what you do for victims, but you really effectuated change not only in laws, but in how the criminal justice system is supposed to work. And your case should really be the poster child of justice. Because I watched your trooper, I watched your prosecutor, and you had a prosecutor and a trooper that understood that their jobs were not to get convictions. Their job was to see that justice was done.
Correct.
And you're fortunate that you had that. And to be in a situation where the guy that arrested you and the guy that prosecuted you are on your podcast, you really you really turned everything around, Clark. And
right.
And even what you've done for my one client, I just hope the change you've effectuated and how many lives you've positively impacted. But in terms of coming to me, I'll talk to anybody about anything. As you can see today, I talk a lot. But it's something that I've developed an expertise in, again, by happenstance. But I feel very blessed to do this type of work. It's hard. You have to fight like hell, but it's very rewarding. And Exhibit A is my client who was on your podcast.
When I asked you, the process just a minute ago, you said the same thing that I say to people when I talk to them about being on the podcast. This is really going to be their first public time talking about it. And I always start off like, look, I want you to be able to talk openly and truthfully with me. I have heard every horror you can imagine. And I apologize for whatever you've gone through. But just, feel free to talk openly with me. And that's what you said, I've heard it all. I've heard it all. Talk freely. It's confidential. I tell them the same thing. It's confidential. I'm not going to go tell anybody about your story. And I also I just recently turned down a coaching client just because what I felt that person needed was a lot deeper than what I could offer them in the situation they're in right now. So it's not like, and the same thing for you. You've turned down people you just said, and continue to communicate with them. I continue to communicate with this person, but it's just not the right fit for coaching.
Yes. Let me just go back to prospective clients. Those Bullock cases, I have three new Bullock cases, but those Bullock cases were litigated for over 10 years.
It's insanity.
And not one person other than, the lawyers know the identities of those individuals. That's how strictly protected it is. Now, they know one because through your work, through his work, he decided, and that's a personal decision. He decided it was best for him to come out, reveal his identity, and really help others. Some people may not be ready for that, never do that. What I could say is it's always confidential. And I kind of walk them through what's required. For attorneys, if you're going to get into this work, you have to take care of yourself. I ended up, and I still have that issue. You start to mentally, right? You start to go down a path where you're hearing these horrors and you're talking to your clients so much, trying to help them out of situations. Maybe you're trying to get them into counseling. They don't want to go and what have you. And it weighs on you. It weighs on you. You know, even driving up here, as I said, I called a client and I said, hey, and it's a current client. I said, what, is there anything you want me to say in this podcast, like a message? And that turned into a 45-minute conversation, and a very upsetting conversation. But the moral of it was something that happens to you as a child, this horrific, changes the complete trajectory of your life. And he was telling me how he often dreams and wonders what his life would have been like had this not had happened to him. And it's upsetting. You know, when we finish those trials, my brother makes fun of me, and it's fine. I make fun of him constantly. I had tears in my eyes because it was over. And we were victorious, and we did it. But I had tears in my eyes because it was such a part of my life for so long. And just like that, it was over. And, you know, as an attorney, you are never allowed to talk to a juror, right? I don't even look at a juror. I don't say hello. You know, you never, during the course of a trial. I never really had an opportunity to talk to jurors. You know, after a case, everybody goes on their way, the judge thanks them and what have you. So I'm up, when we got finished with these cases, my brother's looking at me. He thinks I'm crying. I just had allergies. I didn't even want to leave the sheriff's officers because I bonded with them over the couple of months we were trying these cases. And I could still feel that emotion. And we walked downstairs, and every single juror was waiting for us. It's unheard of.
Wow.
Crying, embracing us, yelling at us. Why did you settle? We were going to send a message. They were talking like tens of millions of dollars. It's ultimately up to our client, you know, whether that case actually settled while the jury was deliberating. But what really comforted, forget about me, was my clients. The jury had like a news conference, and they went, it was a trial for one client, but the other clients testified because of what they had reported it and, you know, fell on deaf ears. And the thing that meant the most to my clients was those jurors said, we believe you. We are sorry that this happened to you. This was horrific. This is awful. I mean, in those trials, one of their strategies was, if the abuse happened, these kids were damaged goods. That's the term their expert used, damaged goods. So they really don't have any other, if Bullock raped them, there's really no more damage because they were already damaged goods.
Wow.
Yeah. Imagine that strategy.
Wow.
These jurors were appalled. I still stayed in touch with them. They actually gave a couple follow-up news stories because this became obviously shorter in time for them, right? A month or two. But it's something that stays with you. And to me, that was the most rewarding part when they spoke directly into the camera and told the victims, we believe you. And that meant a lot to them.
That's awesome, man. Maybe we'll have you back in after this Supreme Court thing gets settled, and we can have some good news for people.
Yeah. No, I'd love to have you tag along, and I know it's a labor of love for you, but please keep doing what you're doing.
Thanks, bro.
I can't tell you, it's actually helped me, mentally as I'm wrestling with things. I see how far you've come, and I still can't thank you enough for what you've done for my client. It was life altering.
You just spoke about how these affect you. I've got when I first spoke, I spoke at Centenary College, and a professor of criminal justice there was a retired lieutenant of Long Branch Police. And he was using my courtroom video as a teaching tool in his criminal justice class, having no idea that I was going to show up there that day to speak. And he was just blown away that just a week prior, he's using my courtroom video as a teaching tool. And then I pop in. He didn't even know I was out of prison. And we instantly bonded. He and I became best friends. And then he went on to be a professor at Seton Hall. And he was hired by a litigator, mostly for victims of Catholic church abuse. Mm-hmm. And they hired him to be the investigator to go get, the depositions from the victims. Mm-hmm. And he called me. He's like, dude, you got to have your phone, ready to go at any time if I need you to talk me off the ledge.
Oh yeah.
And he would call me. He's like, dude, the story I just got from a victim, I want to go do what you did right now. I feel that rage that you must have carried. Like, I just can't believe what I just heard. It's infuriating me. And, we would just talk for 45 minutes and he would calm down and get it out. But the same thing, I'm sure that you've dealt with, it affects your soul. Like, you can't hear these stories and not have your soul affected.
I think it's an understatement. The client we were trying the case for, he had a quote that stuck with me. He said, it's more than the rape of a child. It's the murder of your soul.
Correct. That's what this guy said. It's equivalent to soul murder.
And to me, that was very prolific. And, but yeah, I have to get over the guilt I feel that it didn't happen to me. And I feel very fortunate and very lucky, but it prevents me from truly relating like you can.
Right.
But yeah, Clark, the work you're doing is the countless people you're helping, and as an advocate, I can't thank you enough.
Thanks, Jeff, and I appreciate your work on behalf of victims. So thank you. Thanks for being here, and we'll have you back after a victory with the Supreme Court.
All right. Sounds good, Clark. Thanks,
you. Thanks, bro. There you have it, everybody. If you're out in the audience and you're in New Jersey and you've been abused and you've been debating and you're filled with shame and fear and all the other negative emotions, it's just a phone call. It's just talking to somebody over the phone. Maybe it'll work. Maybe it won't. You can call Jeff Russo in Warren County, New Jersey. We'll see you next week. Peace.